Well, good afternoon, everybody. My name's Edward Denehan, and I welcome you to the first of two webinars I'm put together for discussion about the Renters Reform Bill. There's this afternoon's webinar, and there's a second as soon as tomorrow at 3 p.m. Please come along. In the usual way with my webinars, I don't take questions during or at the end of the webinar, but I'm very happy to deal with general points that might arise from what I speak to by way of email. My email address is on the Chamber's website. Again, in the usual way, I've produced full papers for the both webinars, and they will be distributed together with the PowerPoint slides for what they're worth to all delegates after the second webinar tomorrow, sometime after tomorrow. I'm not suggesting tomorrow early evening, but probably this week. So the first paper is concerned with, as I say, the bill, which I'll call the Renters Reform Bill, and it was introduced by the current government to give effect to a party manifesto commitment to abolish no-fault evictions. It was introduced to Parliament as recently as the 17th of May 2023, and although it does seek to abolish no-fault evictions, it does much more than that, as I shall describe. The sponsoring department is the Department of Levelling Up, Housing and Communities, and the relevant Secretary of State is Michael Gove. When I wrote the papers earlier this month, the first reading of the bill in the Commons had been completed, and the second reading was in progress. Forgive me, I've been away, I haven't checked whether that remains the case, but I rather suspect it is. In a recent podcast that I just happened to be listening to, Michael Gove explained that as the principal elements of the bill are uncontroversial, he expects the bill to receive royal assent and pass into the law by the end of 2023. We shall see. The bill has five parts as follows. There's part one, it's called tenancy reform. Part two, residential landlords. Part three, enforcement authorities. Part four, supported and temporary accommodation. And part five, general. In this paper, I shall address two of the provisions in part one, that's tenancy reform, which itself contains three chapters. I will speak to chapter one and chapter two today. Those chapters are first, assured tenancies, and chapter two, tenancies that cannot be assured tenancies. My original proposal was to speak to the third element of part one, namely penalties for unlawful eviction or harassment of occupiers. But that produced a paper of such length that it was impossible to deal with it adequately in the hour that we have. I'm going to be pushed in any event. So I've rolled that element of the first paper into tomorrow. Rest assured that all the elements are comprehensively addressed in the paper. So let's start with tenancy reform, and I start with a short revisit to provisions made to the Housing Act 1988. I do that because the most significant clauses in the bill, in my view, make substantial amendments to the Housing Act 1988, and therefore, in order to put the proposed amendments in context, it's necessary, I suggest, to revisit parts of the 1988 Act. It's not comprehensive, it's an outline only because it's fairly well known, and as one remembers, it came into force on the 15th of January 1989, and from that date it effectively, but not wholly, replaced the provisions of the Rent Act 1977, the provisions which I, as a junior barrister, cut my teeth on up and down the country in the county courts. The 1988 Act was intended to stimulate the private renter sector by reducing the control on rents that landlords might charge and making it easier, and indeed in some instances certain, for landlords to obtain vacant possession of dwelling houses let on tenancies to which the Act applied or applies still. Putting it simply, the Act 88 Act introduced a new species of tenancies called assured tenancies. That's not strictly correct, because there were beasts called assured tenancies arising under the Housing Act 1980, but let's put those to one side. The assured tenancies as defined in the 1988 Act was a new beast, and the base definition is as follows. A tenancy under which a dwelling house in England is let as a separate dwelling is, for the purposes of this Act, an assured tenancy if and so long as A, the tenant, or as the case may be, each of the joint tenants is an individual, and B, the tenant, or as the case may be, at least one of the joint tenants, occupies the dwelling house as his or only principal home, and C, the tenancy is not one which, by virtue of subsection 2 or subsection 6 below, cannot be an assured tenancy. So the basic definition accommodates tenancies granted to individuals. So company lets were never assured tenancies and won't be going forward. And it's a vital ingredient in the qualification that the tenant occupy the dwelling house as his or her principal or only home. You remember under the Rent Acts, one could have a protected tenancy under Section 1 of the 1977 Act if you were a company and there was no requirement that the tenant actually live in the demised premises. But that was all put to bed in January 1989. Section 1.2 prescribes that if and so long a tenancy falls within any of the paragraphs of Part 1 of Schedule 1 to the 88 Act, it can't be an assured tenancy. And there's a long list. I'll mention some of them. Tenancies entered into before the Act came into force can't be. Tenancies of dwelling houses with high rateable values. Tenancies at a low rent. Tenancies to which Part 2 of the 1954 Act apply. Tenancies of licensed premises, tenancies under which more than 2 acres of agricultural land is demised with the dwelling, tenancies of agricultural holding and farm business tenancies, lettings to students, holiday lettings, tenancy where there's a resident landlord and there are qualifications that have to be satisfied, crown tenancies, and tenancies granted by local authority and other public and quasi-public bodies, something called a family intervention tenancy, accommodation for asylum seekers, and traditional cases such as protected tenancies under the 1977 Act, which survived the change in the law. The main provision in the 1988 Act providing security of tenure is Section 5, and that says that the assured tenancy can't be brought to an end except by obtaining an order of the court for possession of the dwelling house under Section 7 or Section 21, an order for the court under Section 68, 6 big A, in the case of a fixed term tenancy which contains a power for the landlord to determine the tenancy in certain circumstances by the exercise of that power. That would be a forfeiture clause. In the case of an assured tenancy which is a residential tenancy agreement within the Immigration Act, giving notice under the provisions of that Act. And in the case of an assured short-hold tenancy, serving a notice in accordance with Section 57 of the Housing and Planning Act 2016. It's expressly provided in Section 5.1 that service by the landlord of a notice to quit has no effect in relation to a periodic tenancy. If an assured tenancy, which is a fixed-term tenancy, comes to an end otherwise by virtue of a court order of the kind I've just mentioned, or by surrender or any other action on the part of the tenant is entitled to remain in occupation under a statutory periodic tenancy. So if the landlord were to seek to forfeit a fixed term assured tenancy, then Section 5 would bite and turn that tenancy into a statutory periodic tenancy. in Chapter 1 of Part 1 of the 1988 Act, a fixed term tenancy is any tenancy other than a periodic tenancy. And you will have noted from the base definition in Section 1 of the 1988 Act that there's nothing in the definition which provides for the tenancy to be of any particular length. It can be a 999-year lease, could be an assured tenancy or credit assured tenancy. A yearly tenancy clearly could, and a weekly tenancy again clearly could. Section 7 prescribes the circumstances in which a court may make an order for possession against an assured tenant. The grounds are set out in Schedule 2, and Part 1 of Schedule 2 to the 1988 Act contains mandatory grounds for possession. What that means that if the landlord establishes those grounds, the tenant will have an order for possession made against him or her. There is no discretion in it. And there are a large number of grounds which I set out at some length in the paper, but just quickly running through some of them. Ground 1 is a prior notice ground, namely if the landlord gives a notice prior to the tenancy starting that he or she wishes to occupy the premises in the future, or might, as his principal home, they can give a notice to that effect. And if the landlord brings a possession claim relying upon that ground, the court must make an order. Ground 2 and 2A are concerned where mortgagees are exercising power of sale. Ground 4 is letting to a student where notice has been given. Ground 5 concerned with demises to ministers of religion. Ground 6 to grants to buy non-profit registered providers of social housing. The most important ground, I can jump straight through, is ground 8. That provides a ground for possession, a mandatory ground for possession based upon rent arrears. And without reading out the detail of it, if there is a threshold of arrears is met, and it's prescribed then at least 2 months essentially, then the landlord is bound to obtain an order for possession. So in the case of habitually bad payers, the landlord can get possession as of right, provided he or she proves those arrears. Part 2 of Schedule 2 contains discretionary grounds, and what that means is that even if the landlord makes out the ground for possession, the court will only make an order for the possession if it considers it reasonable to do so. So there's 2 requirements. 1, does the landlord make out the ground? And 2, does the landlord satisfy the court that it's reasonable to make an order? So ground 9 is that suitable alternative accommodation is available to the tenant or will be available to the tenant when the order for possession takes effect. Rereading that yesterday for the purposes of today's webinar, it reminded me of a suitable alternative, a case I did a number of years ago, where the offered accommodation was in the building, the house next door to the current dwelling house. It was a ground floor flat. The current tenancy was of a ground floor flat. The current tenancy ground floor flat was a very poor, tatty 1950s conversion with internal steps and so on and so forth. The offered accommodation was the ground floor, all on one level, beautifully fitted out. I was a young man then and would have died to have such an apartment in Holland Park. The tenant was an aged lady, and she didn't want to move. And so notwithstanding that we established that the offered accommodation was suitable alternative accommodation, the court took the view that it wasn't reasonable to make an order because the tenant had fond memories of living in the flat with her late husband, which was somewhat generous. Certainly my lay client thought so. Ground 10 is based upon rent arrears, but at a lower level. So if the tenant has been missing payments, but not habitually and to a high level, then the court has a discretion. If the tenant is in breach of any other obligation owed to the landlord, if the condition of the dwelling house has deteriorated by activities being carried on. There's new grounds now, 14ZA, if anybody residing, an adult residing in the dwelling house is convicted of an indictable offence, which took place at the scene of a riot in the United Kingdom. And so on and so forth. They're all the mandatory grounds there. Sorry, forgive me, discretionary grounds there. Section 8.1 of the 1988 Act provides the court won't entertain a claim for possession of a dwelling house let on an assured tenancy unless the landlord, or at least one of the joint landlords, serves a Section 8 notice on the tenant. And unless the court thinks it just and equitable to dispense with the Section 8 notice, if, for example, the tenant is avoiding service. A Section 8 notice must be in prescribed form and contain prescribed information, but that's a notice to which must be given before the landlord commences proceedings. So if the landlord gets all those ducks in a row, he or she can apply for an order of possession. In the case of mandatory grounds, if the ground is made out, possession will be ordered. If it's a discretionary ground, the landlord has to make out the ground and persuade the court, the burden being on the landlord to persuade the court that it's reasonable to make an order of possession. Chapter 2 of the 1988 Act created a subspecies of assured tenancies called assured shorthold tenancy. There are two relevant provisions, 19A and Section 20. Essentially, all assured tenancies granted from the date the Housing Act 1996 came into force will be an assured shorthold tenancy, and that was the 23rd of August 1996. Before that, the landlord had to take certain steps to create an assured shorthold tenancy. And as I say, from the 23rd of August 1996, all assured tenancies are assured shorthold tenancies, unless it fell within Schedule 2A to the 1988 Act. And that contains a number of paragraphs, and there are certain circumstances where an assured tenancy will not be an assured shorthold tenancy if the landlord gives a notice in advance saying it won't be. If the tenancy itself said it's not an assured shorthold tenancy, then it won't be. An assured tenancy arising by virtue of the Schedule 10 to the Local Government and Housing Act 1989 won't be. Assured tenancy replacing non-shorthold assured tenancies, and so on and so forth. But as I say, since 1996, just about all assured tenancies have been assured shorthold tenancies. I must confess I don't do a lot of assured tenancy work these days, save when it gets a little bit complicated, but I can't ever remember since that date coming across an assured tenancy which was not an assured shorthold tenancy. Section 21, some might say the notorious Section 21, Michael Gove in the podcast I referred to Section 21 as if it were his children's names. And what the Section 21 means is that a landlord, if he or she wishes to claim possession as against an assured shorthold tenancy, must give a Section 21 notice, and it gives essentially 2 months' notice to the tenant. And if a notice is served, and there's certainly in the past there was often difficulties about getting the notice right. If a Section 21 notice is served, the court must make an order for possession against the tenant. So that's the no fault mischief that the bill is primarily, it would seem, intended to address. So in the current climate, we have tenants who are complying with all their obligations under their tenancy, but for whatever reason, the landlord wants possession, and if the tenant does not leave the premises under an assured shorthold tenant, provided the landlord gets its Section 21 notice in proper shape, the landlord will be guaranteed to obtain possession, and that in the current climate is thought to be politically unacceptable. Moving on, the first element in part 1 of chapter 1 so we're now talking about the bill itself at long last, is that it brings to an end certain kinds of assured tenancies. And I've put on the PowerPoint, it's very straightforward. The clause 1 inserts into the 1988 Act a new section 4.1, and it provides that terms of an assured tenancy are of no effect so far as they provide for the tenancy to be a fixed term tenancy. As I said, the basic definition of an assured tenancy says nothing about the nature of the tenancy in terms of periodic or fixed term, but the new 4.1a of the 1988 Act will prevent the creation of fixed term tenancies, even if the tenancy purports to create a fixed term, and therefore one assumes even if the parties to the tenancy agreement would wish to create a fixed term tenancy. Such provisions in a tenancy agreement will be void. Remembering that under the 1988 Act, the fixed term tenancy is any tenancy other than the periodic tenancy. So again, it's all periodic tenancy are caught, fixed term tenancies are caught. Where the terms of an assured tenancy are of no effect by operation of section 4A, the tenancy has effect as if it were a periodic tenancy under which the periods of the tenancy are the same periods of those in respect of rent is payable. Accordingly, if I purport to grant a fixed term tenancy of 2 years at a monthly rent of £2,000, then the tenancy will in fact create, or the agreement will in fact create a monthly periodic tenancy. I've recently advised, very shortly after the bill was put before the House, where my late client grants fixed term tenancies to overseas students for a year with all the rent payable in advance. That would create, if he were to adopt that formula going forward, if this becomes the law, then that tenancy would be converted into a yearly periodic tenancy. If the terms of the tenancy provide for rent to be payable in periods exceeding 28 days or monthly, then the provisions in the tenancy agreement will be of no effect. And essentially what it provides is that the rent periods will be 1 month, beginning with the first day of the tenancy. And the rent for each rent period is to be an amount calculated in accordance with a new section 4.5, 4 big A5, and due on the first day of the rent period. And there's a formula for calculating what, say, an annual rent is on a monthly basis. It's R divided by D times 30.42. R is the rent which would have been due for the first rent period, and D is the number of days in that period. So returning to the tenancy I mentioned earlier, the annual tenancy at rent all in advance, and let's assume the rent was £24,000 for the year, taking 365 days in the year, the rent payable applying this formula, and I've done the maths twice, it's not very difficult if I can do it, it'd be 24,000 divided by 365 multiplied by 30.42 gives a rent of £2,000 and 22 pence per month. Here's another major proposed amendment, the abolition of assured short-hold tenancies that I bored you with just a moment ago. Clause 2 of the bill is commendably simple. It simply removes from the 1988 Act section 6A, chapter 2 of part 1. Chapter 2 of part 1 is entitled Assured Short-Hold Tenancies and contains sections 19 big A to 23. Some of those I've touched upon earlier. So if the bill becomes law, all those sections are removed, and therefore assured tenancies will be no more. So it follows that the predominant form of private sector lettings of dwelling houses since 1989, namely assured short-hold tenancies, will be no more. And therefore the ability of landlords to obtain possession by simply serving Section 21 notice will come to an end, and therefore will bring to an end no-fault evictions. And that is one of the primary goals of the proposed amendments. Clause 3 of the bill changes grounds for possession. And again, it's pretty tortuous stuff because it fiddles around with existing grounds, and inserts new grounds and deletes others. A new ground 1 might be of interest to those who advise landlords, and will provide that at the date specified in the notice under Section 8, the current tenancy had existed for at least 6 months, and the landlord who's seeking possession wants possession of his only or principal home for himself or any of the following, and you've got spouse or civil partner, or to use the old language, common law spouse, the landlord's parents, grandparents, sibling, child, goes on and on, grandchild, child of a person mentioned in B, that's civil partners and so on and so forth. A relationship of the half-blood is treated as a relationship of the whole blood. So it's much more widely drafted than the current ground 1, where it's simply limited to spouses. The family members have been greatly extended. Paragraph 3 of Schedule 1 to the bill will introduce a new mandatory ground for possession by an insertion of a new ground 1A. Again, this is a landlord giving a prior notice. If the landlord wants to sell, he or she can obtain a mandatory ground, has available a mandatory ground for possession. The landlord can't be a registered social landlord within the meaning of the Housing Act 1985, or a housing trust, or a dwelling house is social housing within the meaning of the Housing and Regeneration Act 2008. Clearly that's going to be a valuable ground for landlords who want to own the property as an investment for some while, but may want to sell it in the future going forward. As I say, there's any number of amendments made going through the grounds. I've set them out all here. Specific grounds dealing where superior landlords are seeking possession, as is a new ground 2ZA. Existing ground 3, holiday accommodation, will be admitted from Schedule 2 to the Act by operation of paragraph 8 of Schedule 1 to the bill. Student accommodation, that's modestly amended as I described in the notes. Even more modest amendments to the ground which applies to ministers of religion. And there's a new ground 5, if possession is needed for occupation by an agricultural worker. 5B, possession required for a person who meets certain employment requirements. Existing ground 16, again, an employment ground, is moved to part 1 of Schedule 2 and becomes a mandatory ground. Ground 5D, mandatory ground, landlord seeking possession for an end of employment requirements. Ground 5E, a new one, possession required as supported accommodation. 5F, mandatory ground for possession occupied as supported accommodation. And as I say, all the way down to a new mandatory ground arising on the death of the tenant. There are proposed amendments of ground 8, that's the important rent arrears ground that we've touched upon earlier, and it will provide as follows. It says, when calculating how much rent is unpaid for the purposes of this ground, if the tenant is entitled to receive an amount for housing as part of an award of universal credit under Part 1 of the Welfare Reform Act 2012, any amount that was unpaid only because the tenant had not yet received that award is to be ignored. Now, I do remember from my days doing the general forgive me, during the general possession lists, that frequently the tenant's position was that they simply hadn't received, not universal credit back in those days, but their housing benefit or so and so forth. And therefore, that's an important amendment to assist those who are in receipt of universal credit, so that any delay in payments of universal credit attributable to housing does not count as arrears for the purposes of ground 8, which, as we've discussed, is a mandatory ground for possession. There's a new ground A inserted after the existing ground 8, which we've spoken about. This provides as follows: within a 3-year period ending on the date of service of a notice under section 8, if rent is payable monthly, at least 2 months' rent was unpaid for at least a day on at least 3 separate occasions, or if the rent is payable for a shorter period than a month, at least 8 weeks' rent will be unpaid for at least a day on the at least 3 separate occasions. And so again, that provides a somewhat more protection for the landlords than the position, for tenants than the existing ground 8 ground of possession. There are other slight amendments to the grounds possession. The detail don't lend themselves to an oral presentation, but the detail is set out in the Act, in the bill and in the paper. So what one has therefore is fundamental changes to the operation of the 1988 Act. It's not for a humble lawyer like me to speculate as to how that will impact on the market, albeit that the rumblings that I've heard, both in my practice and from news reporting, is that it's suggested that the number of what I would call amateur landlords, people who own a flat maybe and let that out, may well think twice about making their properties available in the market. For institutional landlords, of course, as I understand it, say if they want to sell up, what they want is a rental income. So provided they've got a tenant there who's prepared to pay, they're very happy for the tenant to pay. But as I understand it, again, from not news reporting, is that unscrupulous landlords are using the mandatory grounds of possession, or the ASTs at the moment more significantly, to put pressure on tenants to agree increased rents, which leads us on to the next subject matter that I want to talk about, and that is increases in rent. And again, it's necessary to remind ourselves of what the 1988 Act provides. And in the first instance, I note that there is nothing in the 88 Act which affects the right of a landlord and a tenant under an assured tenancy, including an assured short-hold tenancy, to vary by agreement any term of the tenancy, including a term in relation to rent. So the landlord says, I want to increase the rent by 25%. And the tenant says no, and the landlord says, all right then, well, I'll serve a section 21 notice and I'll throw you on the street. Then nobody's ever thrown on the street, but you know what I mean. Then that would be a means of forcing the tenant to reach an agreement, and there's nothing in the Act, the 1988 Act is currently drawn, which prevents an agreement like that becoming binding as between the landlord. In addition, under the 1988 Act, Section 13 provides that a landlord can unilaterally initiate a procedure for increase in rent under an assured periodic tenancy. To secure an increase in such circumstances, the landlord must serve on the tenant a notice in the prescribed form, providing details of what the proposed rent will be and when it will start. And when a notice is served, the new rent specified in the notice takes effect unless before the end of the period specified in the notice, the tenant applies to the appropriate tribunal, which is the first tier tribunal, or the landlord and tenant agree a variation which is different from that proposed. So if the landlord serves Section 13 notice, there's nothing to prevent the landlord and the tenant agreeing some other rent. Section 14 of the 1988 Act, as currently drawn, makes provision for the determination of rent payable under an assured tenancy by the appropriate tribunal if there's a reference to the tribunal by the tenant upon receipt of a Section 13 notice. On such a referral, the appropriate tribunal determines a rent which it considers that the dwelling house might reasonably be expected to let on the open market by a willing landlord under an assured tenancy, where the periodic tenancy has the same periods, which begins at the beginning of a new period specified in the notice, the terms of which, other than the rent, are the same as those under the current tenancy, and in respect of which the same notice, if any, had been given under grounds 1 to 5. That's the prior notice grounds for possession. However, in making such a determination, the FTT must disregard the fact that there's a proposed hypothetical grant to a sitting tenant, so it's no interested bidder. Any increase in the value of the dwelling house attributed to improvements carried out by the person who when they carried them out with a tenant, and there's definition of what those improvements are, and any reduction in the value of the dwelling house attributed to the failure by the tenant to comply with its terms of the tenancy. So if the tenant is obliged to repair and it doesn't get to argue in front of the FTT that the rent should be somewhat less than it might otherwise be because the premises are out of repair. Moving forward, the proposed amendments are in clauses 5.2 to 5.8 of the bill, and the proposed amendments introduce tenancies which are called relevant low-cost tenancies, and that pick that one forward, if I may. That's a relevant low-cost tenancy is a tenancy as follows. It's an assured tenancy of social housing within the meaning of Part 2 of the Housing and Regeneration Act 2008, where the landlord is a private registered provider of social housing, and any other assured tenancy of the description specified in regulations made by the Secretary of State. I haven't mentioned it thus far, but I will mention it now, that there are numerous provisions in the bill for the Secretary of State to make regulations to change the scope and of the new provisions. That doesn't find favour with many parliamentarians or lawyers, but there it is. I refer to some of them in the notes. The first substantive proposed amendment in the bill is a new section 13.1, which provide that section 13 applies to any assured tenancy other than a relevant low-cost tenancy. So if you've got a low-cost tenancy, the landlord can't serve a section 13 notice. The existing section 13.4 will be amended as follows. It provides where a notice is served under section 13.2, a new rent specified in the notice shall take effect as mentioned in the notice unless before the beginning of the new period the tenant applies to the appropriate tribunal under 14A3, or the landlord and the tenant agree on a new rent lower than that proposed in the notice. So they can agree a lower rent, but not the rent, or clearly a higher rent. This curb on rent increases is reflected in new section 13.8. That will provide as follows. The rent for a period of an assured tenancy to which this section applies may not be greater than the rent for the previous period, except by virtue of a notice under this section or an agreement under subsection 13.4b following such a notice, determined under section 14, or an agreement in writing between the landlord and the tenant bearing the rent following a determination by the appropriate tribunal under section 14, where the agreed rent is lower than that rent which would be payable under 14ZA or 14ZB as a result of a determination. And any provision relating to an assured tenancy to which this section applies is of no effect so far as it provides that the rent for a particular period of the tenancy must or may be greater than the rent for the previous period, otherwise than by virtue of a notice or determination as mentioned in this subsection. Sorry about that. But essentially what it means is more rent protection for the tenants. Clause 5.9 will insert a new section 13A in the 88 Act, which provides for increased rent in under relevant low-cost tenancy. I won't describe the detail of that in this paper. Section 14 of the 88 Act as amended, that will insert new paragraph sections A1, A2, A3, make provision for assured tenants to apply to the appropriate tribunal for the purpose of challenging the rent. So what that means is that rather than sitting back until a landlord serves a Section 13 notice and then making a referral to the first tier tribunal, the tenant can take the initiative and refer the rent that is payable to the tribunal. And Section 14 ZA, it describes the effect of a determination of the rent payable. It provides that the section applies where the appropriate tribunal makes a determination on an application under Section 14(1)(a) in relation to a tenancy. The rent payable under the tenancy as a result of the determination is the amount of rent determined by the appropriate tribunal in the application, and the appropriate amount, if any, in respect of rates. The rent payable on the tenancy as a result of the determination takes effect from the date the tribunal directs. The date must not be earlier than the date of the application. And in this new section, the appropriate amount in respect of rates means the amount of rent attributable to any rates borne, as mentioned in section 14(5). So again, the overall effect of the changes to section or amendments to Section 13 of the 88 Act as originally drawn, as they operate at the moment, is to increase the rental protection afforded to tenants, whilst at the same time providing a mechanism by which the landlord can achieve an increase in rent if the value of money changes. It's not rent control as we used to know it under the 1977 Act. There's no rent officers to determine the new rent to be payable. You may have seen I kind of skipped ahead because there's interesting provisions. It's clearly a hot potato, the issue of tenants and pets. I've recently been on flights involving flights within the US, and I think it's the first time I've ever seen travelers carrying their, I think they're called comfort pets, so one dog, just about manage that, I suspect, but a comfort cat on a flight, I'm not sure how that would work. But anyway, it's a thing in America, certainly. And there are provisions in the bill, clauses 7 and 8, dare I say, extensive provisions dealing with tenants' abilities, if not rights, to keep a pet. Don't think me anti-pet. We have a pet ourselves, but as I say, reading these provisions, it does seem rather extensive and burdensome provisions for something that might not be thought to be that important, but perhaps I'm wrong. It starts it that there's going to be an implied term of every assured tenancy to which new Section 16 Big A applies, that the tenant can keep a pet at the dwelling house if the tenant so requests and the landlord consents. And it'll be an implied term that the landlord can't unreasonably withheld consent. Procedures prescribed, quite involved procedures prescribed for the provision of information to the landlord about the pet. Did it come from a good family, I suppose, that sort of thing. And provision is made where cases where there's a superior landlord's consent is required. So it's a double layer if necessary. The new Section 16A, which deals with the permission to keep a pet, does not apply to a tenancy of social housing within the meaning of Part 2 of the Housing and Regeneration Act 2008. Deduce your own policy reason for why that might be. The new Section 16B4 describes certain circumstances in which it would be reasonable for a landlord to refuse consent. The list is not exhaustive. The circumstances are the pet being kept at the dwelling house was caused the landlord to be breach of an agreement with the superior landlord, or an agreement between the landlord and the superior landlord prohibits the keeping of a pet at the dwelling house without the consent of the superior landlord, and the landlord has taken reasonable steps to obtain that consent, but the superior landlord has not given it. Funnily enough, these provisions will give the tenant a cause of action against the landlord for a breach of the implied term concerning pets. And it's expressly provided that the court may make an order for specific performance of the obligation. So that would be a mandatory order requiring the landlord to consent to the keeping of a pet in the dwelling house. The express reference to the court's ability to make an order for specific performance does not of itself eliminate the court's jurisdiction to award damages for breach of the implied term concerning the pet. One can imagine that if a tenant has to house the pet somewhere else, that could give rise to a monetary loss. Query whether the tenant could claim damages for the anxiety, emotional distress, or other difficulties arising from being unable to keep their pet with them. That'd be quite interesting new developments in the law in that field. A new section 16C also concerns implied terms, and it will be an implied term of every assured tenancy to which section 16D applies, that if at the time of consenting to keeping a pet, the landlord informs the tenant in writing that one of the following is a condition of consent, the tenant must comply with the condition. The conditions are that in respect of the time the pet is in the dwelling house, the tenant maintain insurance that covers the risk of pet damage to a level that is reasonable having regard to the pet and to the dwelling house in question. So if one's keeping a pet cougar or other big cat in a high-end dwelling house, the insurance might well have to be substantial. The contrary of that is true as well, I suppose. That the tenant pay the landlord's reasonable costs of maintaining insurance that covers the risk of pet damage in respect of the time the pet is in the dwelling house to a level that's reasonable having regard to the pet and to the dwelling house in question. Clause 7.2 inserts a new section 4, new provision in 45.1 of the 1988 Act. Section 45.1 of the 1988 Act contains definitions, and the definitions, not surprisingly, is a definition of a pet. And a pet is defined as being an animal kept by a person, mainly for A, personal interest, B, companionship, C, ornamental purposes, or D, a combination of A, B, and C. I'm not sure what ornamental purposes are for a pet. Maybe just one of these small dogs that simply doesn't move and just looks pretty. But anyway, whatever it is, the pet is, if it's within that definition, then it can be kept. There's no restriction on the species of animal a pet might be, so it would cover exotic large cats or snakes or other reptiles. One might be interested in snakes to personal interest rather than companionship, but who knows. Clause 8 contains seems to be very extensive provisions concerning pet insurance. So going forward, pet-loving tenants will have a whole bag of rights arising under these implied terms, which they can rely upon to ensure that they will not be parted from their beloved pet. As I say, the provisions are somewhat involved and surprisingly involved, having regard to the nature of the issue that it's seeking to address, but that's just my view. Again, sticking with tenancy reform, there's duties of a landlord. I'll take this element of the bill quite quickly. Clause 9 will place a duty on landlords to provide written statements of the terms and conditions to the tenant on or before the first day of the tenancy. Pause there. An assured tenancy doesn't have to be created in writing unless it's otherwise so required under the general law. And now they can't be fixed. There won't be fixed term tenancies. That's no real problem about that at all. This will include whether the landlord wants to or might use a prior notice grounds for possession that we talked about. Clause 10 will insert a new clause, section 16E, which prohibits certain actions by the landlord or former landlord on the assured tenant. The prohibited actions, which will not apply to assured tenancies of social housing, will include letting a fixed term tenancy, serving an incorrect form of possession notice, failing to give prior notice when it's required, specifying a ground for possession that the landlord is not entitled to use, a notice that specifies a date for starting possession proceedings earlier than 6 months after the start of the tenancy when using the occupation, selling or redevelopment grounds for eviction. Pause there for a second. Those earlier bullet points I mentioned, serving incorrect form of notice, failing to give prior notice, specifying ground that landlord's not entitled to use. I'm not sure why that is specified as a duty, because if the landlord does any of those things, it just means the step is otiose. It doesn't have effect. The landlord specifies a ground 8, mandatory ground of possession, and it doesn't have the evidence to support that ground, then it will simply fail. But anyway, and it was also, this is an important restriction, the landlord will be prevented from reletting or remarketing a property within 3 months of obtaining possession on the occupation or selling grounds for eviction. As I say earlier on, that mandatory grounds for possession include where the landlord, paraphrasing, wishes to occupy the dwelling house, or his family members wish to occupy the dwelling house, or the landlord wishes to sell. So there's got to be a hiatus of 3 months from obtaining possession and exercising the innate ability of a landlord to sell his or her property. I'm not sure where 3 months takes us. It doesn't help the tenant who's already been thrown out of the premises. It just means the landlord's got to sit on it for 3 months. I don't know. Clause 11 will add new sections to the 88 Act, setting out financial penalties and offences that will apply where the landlord breaches the prohibitions in clause 10 and a failure to provide a written statement of terms. It may well be, I don't know, that, well, it's not clear to me anyway, that if the landlord, for example, maliciously specifies a ground for possession that is not entitled to rely upon, with a view of intimidating the tenant and driving them out, then that will give rise to a liability to pay a penalty. Its local authorities are going to be able to impose financial penalties up to £5,000 if satisfied, quote, beyond a reasonable doubt of a contravention of clauses 9 or 10. And no penalty may be imposed in certain circumstances if the landlord has been convicted of an offence under section 16G. So but the new provisions will apply for an imposition of a financial penalty by the local authority, or the creation of a criminal offence under section 16G, which will give rise to an obligation to pay a fine. And it's, as I say, new section 16G sets out the offences, which will attract a penalty of up to £30,000. Again, including where a landlord serves a notice specifying a possession ground they are not entitled to use, and the tenant leaves the tenancy without an order for possession being made. So I've answered my own question, as it were. If the landlord uses grounds for possession as a weapon of intimidation against the tenant, hoping that will drive them out, and the tenant goes, then he, the landlord, or she, the landlord, will commit a criminal offence. Hard to know, difficult to know, just or to understand how that will work. The tenant would have to retrospectively report this to the prosecuting authorities. I don't know. As I recall, there's no provision in the Act that prescribes a procedure. A new section 16G offence will also be committed if a landlord remarkets a property within 3 months of using the moving or selling grounds, or instructs a letting agent to do so. So that's a criminal offence. Again, I'm not entirely sure what the policy behind that 3 months hiatus is, but there it is. There will be a continuing offence where the landlord or a former landlord receives a financial penalty for a prohibited conduct and continues the conduct for more than 28 days thereafter. Repeat breaches will occur where the landlord or former landlord conducts themselves in a way that gives rise to a liability to a financial penalty under section 16F, as it will be within 5 years of receiving a penalty for a different conduct. So if you have an habitual offender landlord, then they are at greater risk as to prosecution. A new section 16H provides for a local authority to impose a fine up to £30,000 if it's satisfied beyond a reasonable doubt that the person is guilty of an offence under 16G. The section specifies circumstances in which a fine may not be imposed, including where criminal proceedings have been commenced but not concluded. A new 16I provides for the Secretary of State to provide financial assistance to local authorities to support their functions under these new provisions. That's section 16F to 16H. It would also provide a power through which the Secretary of State may amend the maximum penalty levels specified in section 16F, 5,000, or 16H, 30,000 by regulations, but limited to reflect the fall in the value of money. Clause 10 of the bill will insert a new clause, new Schedule 2ZA to the 1988 Act. This sets out the procedure for local authorities to follow when imposing financial penalties, including rights of appeal and enforcement. Clause 13 provides that the new section 16G does not apply to the Crown. Clause 14 will amend the Protection from Eviction Act to specify the amount of a notice that a tenant will need to give when ending an assured tenancy. The default notice will be 2 months, but the landlords and the tenants are able to agree a shorter period in a separate document. Clause 15 provides that it's possible to withdraw a notice to quit once served if the landlord and tenant agree in writing. It's not normally possible to withdraw a notice to quit unilaterally under the general law. Clause 16 will amend the 1988 Act to limit the circumstances in which a landlord is obliged to pay for removal expenses when a court orders possession of a dwelling house on ground 6 redevelopment or ground 9 suitable alternative accommodation. In future, only private registered providers of social housing will be required to pay the tenant's removal expenses in such circumstances. Clause 17 concerns grounds of possession against those with assured agricultural occupancy. I won't say anything more about that. Clause 18 concerns the duties of local authorities in respect of accommodation for the homeless. And Clause 19, concerned with tenancy deposit requirements, amends the Housing Act 2004 to continue the requirement for deposits to be protected in respect of all new tenancies that were ASTs immediately before the extended application date. The commencement and application of Chapter 1 is dealt with as follows. Clause 67 of the bill is concerned with commencement and application, and Chapter 1 of Part 1 will come into force on such day as the Secretary of State may, by regulations, appoint, and that's called the commencement date. 67.2 provides that Chapter 1 of Part 1, this is a tenancy reform we've been looking at, in relation to every assured tenancy entered into on or after the commencement date, which I've just mentioned, it will provide that from the extended application date, Chapter 1 of Part 1 applies in relation to every assured tenancy, including those created as ASTs, that was entered into before the commencement date and continues in effect on the extended application date. The extended application date is a date appointed by the Secretary of State by regulations, except where an existing assured tenancy created before the commencement date, including those created as ASTs, is converted to a periodic tenancy between the commencement date and the date appointed by the Secretary of State, in which case it is the date on which the tenancy converts. Now, what all that means in practice, as far as I understand it, there will be a 2-stage transition to the new tenancy system. In the first stage, all new tenancy will be governed by new rules from the commencement date. That's straightforward. In the second stage, existing tenancy will transition to the new system on the date appointed by the Secretary of State, or on the date they convert to a periodic tenancy if that is earlier. So imagine, if you will, that there's a fixed term assured tenancy. When that comes to an end, all other things being equal, a Section 5 statutory periodic tenancy will arise. If the bill becomes the law and the Act is 88 Act is amended as we've described, then when that fixed term tenancy, albeit that it was granted before the amendments to the 1988 Act come into force, when that is converted to a periodic tenancy, the new rules will apply to that. And of course, as the first stage on that list provides, all new tenancies, once the Act is amended on that commencement date, will be subject to the new rules. Very quickly, tenancies that cannot be assured tenancies. There's a new tenancy that can't be an assured tenancy. It's Part 1 of Schedule 1 to the 88 Act. A fixed term tenancy of a term certain of more than 7 years from the date of the grant of the tenancy. So a fixed term tenancy for a term of certain of more than 7 years from the date of the grant will not be an assured tenancy if the bill becomes law. And as I've said more than once now, under the 1988 Act, a fixed term tenancy means a tenancy other than a periodic tenancy. I've assumed that the reasoning behind this provision is that a tenant under a fixed term tenancy of 7 years or not less than 7 years is sufficient security of tenure and therefore doesn't require the protection of the 88 Act. And if a tenant is taking such a fixed term, he or she probably doesn't need rent protection. Also, as ground rents have increased over the years, some long leases have become assured tenants. As a result, landlord can seek orders of possession where there are 3 months ground rent under arrears. This amendment will stop that happening. An interesting point that arose in the case I was asked to look at on the day after the bill was published, whether a fixed term of more than 7 years, which contains a landlord's break option, is a fixed term tenancy for a term certain of more than 7 years within the new paragraph 3D, which is on the screen. There's no authority that I'm aware of which describes what a term of years certain means at common law, and there's authority where that's been observed. There are authorities where it's been held that a fixed term tenancy with a break clause is a term of years certain, but they have been concerned with the use of the expression in particular statutes, particularly the Landlord and Tenant Act 1954. So the construction of the words on the screen at the moment, a fixed term tenancy for a term of years certain, more than 7 years from the date of the grant, will have to be construed in the context of the 88 Act as a whole, as amended. My view is that the existence of a break clause, either exercised by either the landlord or the tenant or both, will result in the fixed term of more than 7 years not being a term certain. It'll be a fixed term tenancy for more than 7 years, but it won't be a term certain. But I may be wrong about that. We'll have to see. Well, that's all I'm going to speak to today. Tomorrow, we'll be looking at penalties for unlawful eviction or harassment, the residential landlords, the landlord database, and other such interesting things. So I hope you can join me tomorrow at 3 o'clock for the second part of the Renters Reform Bill webinar series. Have a good afternoon, everybody.